Hello and welcome to BYJU'S IAS. Let's get started with the analysis of today's The Hindu newspaper, beginning with a news item on page number 1 of the Delhi edition of The Hindu relevant for GS paper 2. Yesterday we discussed in detail contempt of court. Noted activist and lawyer Prashant Bhushan has been convicted for contempt of court. Why? Because through his tweets he scandalized the judiciary. But what is this newspaper article all about? Yesterday, the court had to decide quantum of punishment. And what the court has done, it has given 2 to 3 more days to Prashant Bhushan. Maybe he will submit an unconditional apology. And if he does, which is highly unlikely that he will unconditionally apologize to the Supreme Court, but if he does, then maybe punishment will not be given to Prashant Bhushan. Interestingly, Attorney General of India, who is the first law officer of the country, he has also said that dear Supreme Court, once you have convicted him, but please do not punish him because he has done a tremendous amount of public good. So let's wait and watch what happens on August 24, whether Prashant Bhushan will be awarded punishment or not. Now let's look at another newspaper article on page number 14. Sri Lanka to draft new constitution, and this new constitution is going to jettison, abandon, discard 19th amendment to Sri Lankan constitution, which was enacted by Sri Lankan parliament in 2015. Let's look at what is this 19th amendment to Sri Lankan constitution. This 19th amendment, the main thing about this amendment was that it diluted 18th amendment to Sri Lankan constitution, because it was this 18th amendment to Sri Lankan constitution which gave the president of Sri Lanka extreme powers. And how 19th amendment diluted this 18th amendment? This 19th amendment in 2015, it established something called a constitutional council. And what is this constitutional council? This constitutional council is exercising some of the executive powers, because these executive powers were previously held by the president of Sri Lanka. So long story short, Sri Lanka is going to draft a new constitution. This new constitution, definitely what it will do, it will jettison, abandon, discard 19th amendment to Sri Lankan constitution, which was passed in the year 2015. But what was the main thing about this 19th amendment? It diluted the 18th amendment. How it diluted the 18th amendment? It enacted a constitutional council, and this constitutional council exercises some of the executive powers, and these executive powers were previously held by the president of Sri Lanka. But what is this constitutional council? It is a 10-member council, and what this 10-member constitutional council does, it monitors the working and functioning of various commissions. Commissions such as Election Commission, Public Service Commission, Human Rights Commission, Finance Commission, University Grants Commission, Audit Commissions. That means because of 18th Amendment, all these important institutions, all these important commissions, they were controlled by the president of Sri Lanka. This 19th Amendment, what it did, it diluted the powers of the president, set up a constitutional council, and it is this constitutional council which monitors the functioning and the working of these important commissions. This 19th Amendment, what it also did, it limited the term of president. Two-term limit was set on the president. That means a president of Sri Lanka cannot be elected more than twice. Also, previously the term of the Sri Lankan president was 6 years. This term was reduced to 5 years by this 19th Amendment. This 19th Amendment, it also did something significant. What it did, it strengthened the Parliament of Sri Lanka. How it strengthened the Parliament of Sri Lanka? Number one, President of Sri Lanka cannot dissolve the Parliament of Sri Lanka until the expiration of 4.5 years of its term. That means, can President dissolve the Parliament of Sri Lanka? Yes, but only after 4.5 years of the term of the Parliament has expired. That too, if Parliament passes a resolution by two-third majority. That means 18th Amendment to Sri Lankan Constitution, it had given wide powers, extreme powers, and now those powers were snatched and ultimately Parliament was also strengthened. It is because of this 19th Amendment that the number of ministers, a limit was imposed. There could be only 30 ministers in the government. That is how this 19th Amendment, it clipped some of the extreme powers of the president and also strengthened the parliament. And now this new constitution is going to abandon this 19th Amendment. But from your examination point of view, you also need to understand about the 13th Amendment to Sri Lankan Constitution. Maybe this is the question that can be asked in your examination. What was this 13th Amendment? This 13th Amendment was possible because of Indo-Sri Lanka Accord. This Indo-Sri Lankan Accord was signed in the year 1987. Why? If you look at Sri Lanka, in the northern and eastern part of Sri Lanka, the Tamils were facing discrimination. That is why there was a civil war in Sri Lanka, which only ended in the year 2009 when LTTE was defeated by the Sri Lankan army. But there was this long held suspicion by the people, by the Tamil minority living in the northern and eastern part of Sri Lanka, that they have been discriminated against by the Sinhalese majority. And that is why their rights have been snatched. They are not provided employment opportunities. Their culture is under threat. Their language is under threat. And that is why there was a civil war. India tried to interfere here. And that is how Indo-Sri Lanka Accord was signed when Rajiv Gandhi was the Prime Minister. And because of this accord, 13th Amendment to Sri Lankan Constitution was made. And that is how Tamil also became an official language of Sri Lanka. Apart from Sinhala, English is going to be the link language in Sri Lanka. 13th Amendment also talks about that more provincial autonomy will be provided to these Tamil areas in the northern and eastern part of Sri Lanka. It remains to be seen what this new Sri Lankan constitution has to say about the 13th Amendment. So what is the newspaper article talking about? Sri Lanka is going to draft a new constitution. This new constitution is going to abandon the 19th Amendment to Sri Lankan constitution. But what is going to happen to 13th Amendment? That we will have to wait and watch. Now let's look at another important column, the marriage age misconception. From the ramparts of the Red Fort, Prime Minister Modi addressed the nation on the Independence Day and declared that government is considering that the legal marriageable age for girls may be increased. Right now, the marriageable age for girls is 18. For boys, it is 21. So maybe marriageable age for girls will also be increased to 21. But this column raises an important question. The author asks, is there anyone demanding in this country that marriage age for girls be increased? The author says no. So why is the government planning to change this? Why is the government planning to address this issue? The author says that the government is mistaken. Why the government is mistaken? The author says that the government is mistaken because it believes that if the marriageable age for girls is increased, then what will happen? The health and the nutritional standards of mothers will also increase. Nutritional standards of infants would also improve. So the author says the government is mistaken if it believes that if we increase the marriageable age for girls, corresponding to that increase, the health and nutritional standard of mothers, the health and nutritional standard of infants would also improve. What is the source of this mistaken belief according to the author? The author says that a survey was conducted in the Lancet Child and Adolescent Health, which is a very prestigious journal, and this survey was funded by Bill and Melinda Gates Foundation. The author disagrees with this report. The author disagrees and says it is not because of marriageable age that the health and nutritional standard of mothers and children and infant is declining. The author says it is poverty and not the age of mother alone that is responsible for this. Last year also, Prime Minister from the same Red Fort address to the nation, he also declared that population explosion is one of India's major problems. Prime Minister said, with an ever increasing population, we have to think, can we do justice to the aspirations of our children? Before a child is born in our home, we must ask if we have prepared ourselves to fulfill the child's needs, or are we going to leave the child to its fate? That is why population explosion is something that we need to tackle. The author here is raising another issue, but that is political in nature. We will not address that issue. Let's look at this newspaper column from a different perspective. If poverty is the sole reason why the nutritional standard of mothers and infants is on a decline, then we need to address this issue, but how? Maybe through cash transfers, which is happening, but we need to increase it. Or is it time to implement something called universal basic income? Regardless of your income, every single individual in this country should be provided a minimum basic income. But now people will complain that if we are going to provide cash to every single individual in this country, the fathers are going to misspend that money. The fathers are going to spend that money for alcohol, spend that money in gambling, spend that money in other unnecessary activities. There is a solution to this as well. When we go for cash transfers, let's give this cash in the hands of a woman. And there have been multiple studies conducted in different parts of this country wherein it has been proven beyond any reasonable doubt that if cash is given in the hands of the woman, she spends it judiciously. So she spends it for health, nutrition, education of her children, and she does not spend on other unnecessary activities. That is why if the issue at hand is that we need to increase the marriageable age for women, because when we do that, corresponding to that, the nutritional and the health standard of women, mothers and infants will also improve. Then for that, we need to address elephant in the room, and that is poverty, because poverty is the single most important reason why the nutritional and health standard of people in this country is on a decline. And how can we address this poverty issue? Maybe it is time for a universal basic income, and this money should be given to a woman because she will not misspend this money. A father may spend the money on alcohol, gambling, cigarettes, but not a woman. But there is another issue which is not addressed by the author, but this is something that we are going to discuss now. If marriageable age for girls is to be increased to 21, what about age of consent? Will age of consent also be increased to 21? What is this age of consent? Age of consent is defined as the age at which one is considered legally competent to consent for sexual activity. Minors, they don't understand their actions and the consequences of their actions. That is why there are laws which forbid sexual activity with children or among children. If we look at Indian Penal Code of 1860, there was age of consent only for girls. And this age of consent was 10 years. That means a girl above the age of 10 can give consent and can indulge in sexual activities. Later on, this age was increased to 12, then to 14, then to 16, and in the year 2013 to 18. So if the age of consent for girls is 18 And if you are increasing the marriageable age to 21, what will happen to the girl in the age group of 18 to 21? Can she still give consent for sexual activity? If the age of consent is also increased to 21, we are going to have more rapists in this country, because sexual activity below the age of 18 is considered as rape. But who gets to decide this age of adulthood? Should it be law that will determine an age? Should it be a biological factor that should determine this age? Or should it be society which should determine what is the age of adulthood? One is mature enough to take decisions. Let's say, for example, the voting age in India is 18. If voting age is 18, why is the age of marriage for a boy 21? There is one question that should be on your mind, is that why is the age of marriage for a boy 21 and the marriageable age for girl only 18? Is it because the lawmakers deem it fit that a man has to take care of his family? That is why he needs to go out and work, and a woman has to do nothing but take care of the kitchen. And for that, once she attains the age of 18, she will be perfect fit to handle the kitchen, and that is why 18 is the marriageable age for women. Isn't this patriarchal mindset of our lawmakers? But the point I'm making is, who decides this age of adulthood? Should it be law? Should it be society? Or should it be biological factors? If it is biological factor, then children today are maturing quite faster. Instead, age of consent should be reduced from 18 to 16, or some people are saying even 14. Why should age of consent be pegged at 18 years of age? You are mature once you cross the age of 18 and you have the right to vote. If you are 16, you are eligible to drive. But if it's a gearless vehicle, if it's a motor vehicle, then the age is 18. You can drink once you attain the age of 18. Some states have 21, some states 23, some states 25. You can adopt a child at the age of 21. A child can also work at the age of 14, because adolescents in the age group of 14 to 18, they can work in non-hazardous industries. So considering all of this, if you are mature to start working at the age of 14, why is the age of consent 18? We had a law called the Child Marriage Restraint Act of 1929, which was popularly known as the Sarda Act. This Sarda Act prescribed the age of marriage as 14 for girls and as 18 for boys. This was later revised to 18 for girls and 21 for boys. This Sarda Act has now been replaced by Child Marriage Act of 2006. One more interesting detail which can be relevant for your prelims examination: there is a convention called CEDAW, Convention on the Elimination of Discrimination Against Women. And this convention deals with marriage and family. This convention says child marriages should not have legal effect. India has signed this convention in 1980. Despite that, child marriages are still okay in India. How? Let's say, for example, a girl less than the age of 18, she cannot marry. But even if she is forced to marry, her marriage is considered voidable, but it is not void. What is the difference? The difference is, let's say there is a girl child, 16 years old. She is forcibly married to a 25-year-old boy or a man, for example. Is this marriage still legal? Yes. This marriage can be annulled only if this girl child files a petition, and only then the courts can annul this marriage. That means if the girl child does not file the petition, this marriage is still valid. And on top of that, this husband gets to consummate the marriage, gets to consume the marriage. That means this husband gets to have sex with this wife. So 25-year-old man marrying a 16-year-old girl, consuming this marriage, having a sexual interaction, shouldn't this be rape? but we do not value and regard marital rape. Marital rape as a concept is still not acceptable in India. It was only in the year 2017 that Supreme Court stepped in. How? There was section 375 of Indian Penal Code. What it did? It said if a girl child is in the age group of 15 to 18 and she marries, and when the husband consumes this marriage, has sexual interaction with his wife, this will not be rape. That means despite the fact that we have age of consent as 18, but if your wife is in the age group of 15 to 18, if a husband is having sexual interaction with his wife, it is not rape because marital rape is not a crime in India. It was only in the year 2017 that Supreme Court came into the picture, and Supreme Court said no. Wife less than the age of 18, even a wife cannot give consent. And if a husband is having sexual intercourse with his wife who is less than the age of 18, it is rape. Something else may also happen. If the marriage age is increased to 21 for girls, age of consent is also increased to 21, then what will happen? A girl less than the age of 21, boy less than the age of 21, what they will do? They will run away, they will elope. Then what the father of this girl will do? He will file a police complaint, and then this boy will be booked. Nothing will happen to the girl child. This boy will be booked, number one, for kidnapping, number two, for statutory rape. And this girl child will come under the influence of parents, and ultimately it tell the police, no, I was kidnapped and raped by the boy, despite the fact that initially she gave her consent. So this age of consent will also have to be factored in if the marriageable age for girl is increased to 21. And there are numerous experts and activists who are saying that the age of consent, which is at now 18, should be reduced. Some say to 16, some say to 14 as well. That is what you need to understand from this newspaper article. Now let's look at another column, less taxing. Yesterday we discussed the National Recruitment Agency. The Union Cabinet has decided to set up National Recruitment Agency, which will conduct preliminary examination or what we call screening test for non-gazetted jobs. Initially, Railway Recruitment Board, SSC, IBPS, their examinations or their preliminary examinations will be conducted by NRA. This editorial first talks about the good points and then lists few concerns as well. Number one, there is going to be one exam. This exam will be conducted in regional languages. The government has said that there is a proposal that in near future, these exams will be conducted in all the 22 languages that are mentioned in Schedule 8 of the Constitution of India. And these exams will be conducted online. That means closer to a candidate's home. So there are huge benefits because of this National Recruitment Agency. Candidates don't have to travel to urban centers to take the examination. And at the same time, a candidate can attempt these tests multiple times. Thereby, the candidate can improve her performance as well. And her best score will be taken into account for recruitments. And at the same time, this best score will be valid for 3 years. So there are lots of good things that will be possible because of this National Recruitment Agency. But the big question is, where are the jobs? And the even more important question is, more specifically, where are the government jobs? If you look at the share of central government jobs, the share of central government jobs is declining rapidly in India. Large number of vacancies today, they are unfilled. Railways, for example, it used to be a big job provider. Now there are talks that we are going to transfer the core railway services to private sector, which means there will be fewer government jobs in railways. What NRA will do and should do, it will cut the delays. That means the problem that we have seen with government jobs They are on a decline over a period of time. But then National Recruitment Agency, apart from these benefits, what it will also do, it will cut the delays. There is delay in exam and there is a government job. They go hand in hand. So whenever government jobs are advertised, there is delay in the conduct of exams. There is also delay in the announcement of results. This editorial hopes that because of this National Recruitment Agency, this delay aspect of a government job will be cut. But then this editorial also says that wide publicity should be given to this National Recruitment Agency so that aspirants are communicated about this. The aspirants know about all the important advantages that this National Recruitment Agency will bring in. Now let's look at another editorial, a losing proposition. There is Article 16 of the Constitution of India, a fundamental right which says that there shall be equality of opportunity in public employment. If you look at the preamble to the Constitution of India, one of the objectives of the Constitution is fraternity, a sense of commonhood, a sense of brotherhood. If you look at Article 19 of the Constitution of India, it talks about freedom of movement. That means you are free to move throughout the territory of India, and you have a fundamental right that you can reside and settle anywhere within the territory of India. So that is the fundamental right provided by the Constitution under Article 19 of the Constitution. Now, what is this editorial about? Madhya Pradesh Chief Minister Shivraj Singh Chauhan has made an announcement that only those who are domicile of Madhya Pradesh, only those would be eligible for government jobs. But what do we mean by domicile? Article 16 says there can be no discrimination on the grounds of residence. That means you cannot prescribe residence as the qualification for government jobs. But there can be discrimination on the grounds of domicile. What is domicile? Domicile is of two types: domicile of origin, domicile of choice. Domicile is residence plus intention to reside indefinitely. What is domicile of origin? Let's say, for example, I was born in Delhi and I stayed in Delhi as well. I did my schooling, college, university from Delhi. That means my residence is also Delhi, but my domicile is also Delhi. Why? Because domicile is residence plus the intention to reside indefinitely. But let's say, for example, I was born in Delhi, but then I made a choice and I traveled to Bengaluru. I did my schooling in Bengaluru, college in Bengaluru, university in Bengaluru. That means although my domicile of origin is Delhi, but I have made a choice that I will reside in Bengaluru for an indefinite period. And I want to make Bengaluru my home. That means I become the domicile of Karnataka. And Supreme Court has said, yes, on the basis of domicile, seats can be reserved in government jobs. Why there can be discrimination on the grounds of domicile? I'll give you one simplistic explanation of this. Let's say, for example, there are jobs announced by the government. Let's say the government of Tamil Nadu. And this job requires that I have to interact with the local population. How can I interact with the local population if I don't know the Tamil language? How can I interact with these people if I don't know about their language, their customs, and their features? That is why, for some jobs, regional particularities are to be considered. That means for some jobs, yes, domicile should be an important criteria on the basis of which the jobs can be provided. But you cannot say 100% jobs will be reserved for domiciles. That's exactly what has happened in Jammu and Kashmir as well. Domicile rules have been made for Jammu and Kashmir Union Territory, and the government has said all those who have stayed in J&K for 15 years or more, they are the domiciles of J&K, and 100% jobs will be reserved for the domiciles of J&K. Despite the fact that Supreme Court has said that you cannot exceed 50% reservation at any cost. Now Madhya Pradesh is also following. Haryana also recently said that they are going to reserve jobs for the domicile of Haryana. Initially, there were these regional political parties who were raising this issue called sons of the soil. That means resources, jobs of a particular state should be reserved for the sons of the soil, should be reserved for the residents of that state, should be reserved for the domiciles of that state. So this cry was raised by regional political parties. Let's say Shiva Sena, for example. Shiva Sena, they attacked initially people from Tamil Nadu because they assumed they are snatching the jobs of the people of Maharashtra. Then Shiv Sena went against people from Bihar and Uttar Pradesh. That means this concept, sons of the soil, this was raked by regional political parties. And now what we are seeing national political parties like the BJP and the Congress, they're also raising this issue. It is the BJP government in Madhya Pradesh which has announced this, and it is the Congress National Political Party in Madhya Pradesh which has supported this government decision. But again, even if you want to reserve jobs for the domiciles, where are the jobs? Unemployment is at a 46-year high. And this editorial says that this cry that jobs will be reserved for the locals, it is only to misguide the gullible population. It is only to fool the population. Why? Because Gujarat, for example, for many years, Gujarat has been raising a hue and cry that there should be a domicile quota of 85% in private sector in Gujarat. That means all these private companies in Gujarat, 85% of their employees should be the domicile of Gujarat. They're raising this hue and cry every single time that there should be domicile quota for Gujaratis in private sector in Gujarat. But when the data was released, the government data in 2017 said 92% of the employees in the private sector in Gujarat, they are the domicile of Gujarat. So you are raising this issue only to misguide the voters, only to misguide the gullible population of this country. And if you're going to reserve all these jobs or majority of these jobs for the localites, for the domiciles, then what will happen? Investment will take a hit, growth will take a hit, because then the companies will not invest in your states. The companies will not invest if they cannot attract talent for their companies, for their business ventures. That is what this news editorial is all about. Now let's look at another column. Should women be entitled to menstrual leave? Last week, Zomato announced a new paid menstrual leave policy for its employees. 35% of the employees in Zomato are women. And what Zomato has done, it has said that every woman employee should be provided 10 days of menstrual leave every year. There are some people who are in favor of this policy and they want to extend this policy to all the companies in government as well as in private sector. Barkha Dutt is against it. Kavita Krishnan is in favor of this. Barkha Dutt says she is against this period leave. Why? Because she is opposed to gendering of the workplaces. And what do we mean by gendering of the workplaces? Let's say, for example, there is a biological difference between a man and a woman. More often than not, women are not given important tasks, important assignments because they are considered physically weak in handling these tasks. And that is why till recently women were not allowed for combat role in Indian Army as well, because it was thought that they are physically weak. Because of this biological difference, they were treated inferior to men. And now if you want to have 10 days of period leave every year, you are going to genderize a workplace, and that is something Barkha Dutt is not agreeing to. Kavita Krishnan says there is no problem with this period leave. Because even if there are biological differences, that does not mean we cannot have different rules for different set of people. Because Barkha Dutt, you should not say that if there are differently abled people and if they want to access workplaces, we can't say that this workplace should not provide ramps to these differently abled people so that they can work in an efficient manner in a workplace. Long story short, whether there should be period leave for women or not, there is a debate going on in the country. This newspaper column gives us the inputs of two women. One is anti-period leave, the other is pro-period leave. Barkha that says I'm against it because I'm against gendering of workplaces, because biological difference should not be the basis of any discrimination. Kavita Krishnan says, I will give you a simple example. We say ramp should be provided in places so that people with wheelchairs are able to access these places. Would that be biological determinism? Would we then say biology is coming in the way of equality? We don't say that. But let's understand this issue from a broader perspective. In 2017, one Congress MP, Ninong Ering, this Congress MP introduced a bill called Menstruation Benefits Bill. What this bill said, that every female employee should be provided 2 period leaves per month, which is 24 days of period leave in a particular year. This bill ultimately lapsed. But why is Zomato providing only 10 days of period leave? If there are 12 months in a year, why only 10 leaves? And that too, the CEO of Zomato says women should apply for period leaves when they really need it. And when you say when you really need it, that means you should not make an excuse not to work and apply for period leave. But you need to understand, I am a man. I don't understand what women go through when they are on their periods. So I can't say this policy is good or this policy is bad. What I can do and what I should do, talk to women and tell them exactly and ask them, what do you want? There are some women who say period leave is a stupid idea. Why? Barkha, for example, she says, when I covered Kargil war while I was on my period, so why should other women need break to work in the office? There are other women who say, yes, periods can be uncomfortable. They can be painful as well. But for that, we have Tylenol. For that, we have Meftal. These are the drugs that can be prescribed. Although some people disagree, some people say you should not take drugs while you are on your periods. But there are some who say, I take Tylenol, I take Meftal, and all is good. Some people say, no, we only need a hot water bottle. Some people say there should be no period leaves because we can apply for sick leave. But amidst all of this, we forget that there is one example in Bihar. Quietly, Bihar, since 1992, it is providing 2 days per month special leave, that too for biological reasons, to women. So if Bihar can implement such a policy quietly since 1992, we should implement this at the national level as well. But when Zomato CEO says women should apply for period leaves when they really need it, that means he is suggesting that women may also misuse this period leave. That means he is suggesting that women may also misuse. That means he is suggesting that women should apply for period leaves only when they are unable to work. What as a man I can do? I will give a benefit of doubt and I will not second guess whether these women are really unable to work or not. But one big thing and beautiful thing that will happen because of these period leaves is that the stigma that is attached to this menstrual blood, this stigma will disappear. When you are going to mainstream this conversation over periods at workplaces, then the taboo, the stigma that is attached to menstruation, that will also disappear. Because let's accept this. One of the biggest selling sanitary pads is known as whisper. Shh, don't even mention this word. Even mentioning this word is a taboo. So this taboo, this stigma would disappear if period leaves are provided at the national level to every single woman who needs it. That is all that you need to know from this newspaper article. Now let's look at some of the practice questions, first for prelims and then for mains. Swachh Survekshan is an annual survey of cleanliness, hygiene and sanitation in cities and towns across India. Correct? It was launched as part of Swachh Bharat Abhiyan Urban. Correct? The first survey was undertaken in 2017. No, it was undertaken in 2016. So only 1 and 2 is the correct answer. Indore wins cleanest city title again. Let's look at another question. India sealed a nuclear energy agreement with Sri Lanka in 2015. Why this question? Because we discussed something related to Sri Lankan constitution. The 13th amendment to the constitution of Sri Lanka is amendment to the constitution of Sri Lanka which created provincial councils in Sri Lanka. Correct? The amendment also made Sinhala and Tamil as the official languages of the country. All these statements are correct. Although these provincial councils, they have not been given autonomy, but even then these provincial councils have been created. Question number 3. Which of the following statements regarding Maternity Benefit Act of 2017 is or are correct? Because we discussed something related to women, that is why this question. The act has increased the duration of paid maternity leave available to working mothers from 12 to 26 weeks. For women who already have 2 surviving children, are they entitled to paid maternity leave? Yes, but only for 12 weeks, not 26 weeks. Provisions for adopting mother who are entitled to maternity benefit of 12 weeks from the date on which the child is being handed over to the mother. That means a mother who is adopting a child, she can also avail maternity benefit for 12 weeks. And any establishment which employs 50 or more employees, it is mandatory for them that they will have the facility of a creche. All these statements are correct. Which article of the Constitution of India safeguards one's right to marry the person of one's choice? That's Article 21, right to life and personal liberty. Mains based question. Question number 1. In reviewing the age of marriage, the government would also have to consider how the law is to be implemented in a society which is riddled with economic inequality. Comment. Question number 2. The time has come to seriously consider introducing a law that makes it mandatory for employers to grant women menstrual leave. Critically analyze. Please write answers to these questions, submit to us, and we shall pick them up. That is it from our newspaper analysis for today. Thank you for being with us. Have a great day.